When code punishes, automated government decisions, due process, and the lessons of China and Australia. Welcome to China-Australia Topics, a weekly podcast where we unpack how law, technology, and governance collide across jurisdictions. Today's episode asks a deceptively simple question: what happens when government punishment is decided by machines? Our discussion is grounded in a recent Chinese administrative law article, Legal Risks and Regulation of Automated Administrative Penalty Procedures.
自动化行政处罚程序的法律风险及规制
By Wang Yachao.
王亚超
Published in December 2025 in the Open Journal of Legal Science, the article examines how automated administrative penalties, fines, sanctions, and enforcement decisions generated or executed by algorithmic systems promise efficiency, but also threaten procedural justice, proportionality, and accountability. This topic resonates powerfully in Australia because of one word: robo-debt. The robo-debt scandal showed what happens when automation replaces discretion, and efficiency eclipses legality. Before we proceed, let's introduce two core Chinese legal concepts that will guide this episode. Automated administrative penalties,
自动化行政处罚
sanctions imposed through algorithmic or digital systems, the principle of due process,
正当程序原则
a cornerstone of Chinese and Australian administrative law alike. Why does this matter globally? Because automation is quietly redefining the relationship between citizens and the state. Section 1, Legal and Technological Background. China's push toward automated administration did not emerge in a vacuum. In 2017, China released the New Generation AI Development Plan,
新一代人工智能发展规划
calling explicitly for AI deployment in administrative enforcement, urban governance, environmental regulation. Later, the implementation outline for building a rule of law government.
法治政府建设实施纲要 2021-2025
Framed digital governance as central to the rule of law state. This context, automated administration,
自动化行政
refers to administrative processes in which specific or all stages of decision-making are executed by AI systems, with minimal or no human intervention. Common examples include traffic fines issued by camera systems, environmental penalties triggered by sensor data, regulatory fines generated by compliance algorithms. From a governance perspective, these systems promised efficiency, consistency, reduced manpower costs, but law does not measure success by speed alone. The rationale appears sound at first sight. Wang points out three major benefits of automated governance. 1. Converts legal norms into digital codes. Since automated administrative penalty procedures are made through an artificial intelligence platform that converts legal norms into digital codes, the administrative penalties imposed on illegal acts with the same parameters are theoretically consistent, which can largely alleviate the situation of different penalties for the same case in grassroots law enforcement.
并且由于自动化行政处罚程序是通过对法律规范转换为数字代码的人工智能平台做出的，因此对于同一参数的违法行为做出的行政处罚理论上具有一致性，能够在很大程度上缓解基层执法存在的同案不同罚的情形。
But law does not measure success by speed alone. 2. There is also the issue of administrative collaboration. Automated administrative penalty procedures can improve cross-departmental collaborative mechanisms, break down departmental data barriers, build a joint law enforcement system, promote the upgrading of law enforcement mechanisms from lone wolf to collaborative governance, and effectively improve governance efficiency.
自动化行政处罚程序能够完善跨部门协同机制，打破部门数据壁垒，构建联动执法体系，推动执法机制从单打独斗王亚超向协同共治升级，切实提升治理效能。2.
Record and trace each step in real time. Automated administrative penalty procedures, through the integration of systems plus technology, can construct a fully traceable law enforcement constraint mechanism. From case initiation to execution termination, the artificial intelligence system can record and trace each step in real time, achieving automatic identification of illegal facts, automatic prompts for the penalty process, and online recording of special circumstances, ensuring that every operation is verifiable.
自动化行政处罚程序通过制度加科技的融合，能够构建起全程可追溯的执法约束机制，从案件启动到执行终结，人工智能系统能够实现对各环节实时记录留痕，尽可能实现违法事实自动识别，处罚流程自动提示，特殊情况线上留痕，确保每一步操作有据可查。
Section 2, Core Legal Analysis. Risks of Automated Punishment. Wang Yachao's article identifies three major legal risk clusters. 1. Risk to due process.
正当程序风险
Traditional administrative penalties involve notice, opportunity to respond, explanation of reasons. In automated systems, decisions may be issued instantaneously. This creates what the article calls procedural program compression.
程序压缩
When penalties are generated in milliseconds, affected individuals may lose right to make representations,
陈述权
right to defense,
申辩权
right to a hearing.
听证权
Chinese law does not exempt automated systems from procedural fairness obligations, and here is where the comparison with Australia becomes unavoidable. The robo-debt parallel, Australia's robo-debt scheme used automated income averaging to issue welfare debts. Key features: algorithmic calculations, reversed burden of proof, minimal human review. Courts later found the robo-debt program unlawful, not merely unfair. The lesson mirrors Wang's argument precisely. Automation does not suspend due process, it intensifies the need for it. 2. Risk to proportionality.
比例原则风险
Another core concept, principle of proportionality.
比例原则
In Chinese administrative law, penalties must be appropriate, necessary, balanced. Automated systems tend to standardize outcomes. This creates the binding of discretion.
裁量基数化
Instead of tailoring penalties to circumstances, algorithms apply fixed thresholds. The result, disproportionate punishment.
过罚不当
Inconsistent outcomes in similar cases.
同案不同罚
Robo-debt again offers a warning. Automated consistency can still produce systemic injustice. 3. Risk to evidence legitimacy.
证据合法性风险
Automated penalties rely heavily on electronic evidence.
电子数据
Chinese law requires that devices be lawfully installed, evidence collection be transparent, public notice be given. If the device, location, or process is unlawful, the penalty collapses. This echoes Australian administrative review principles, where unlawful evidence taints decisions. Automation magnifies, not mitigates, evidentiary risk. Section 3, Regulation, Reform, and Human Intervention. Wang Yachao does not reject automation. Instead, the article proposes structured regulation. 1. Reconstructing due process for automation. The article argues for a technical due process principle.
技术性正当程序原则
This includes neutrality,
中立性
participation,
参与性
transparency.
公开性
Algorithms must be auditable, explainable, contestable. This directly responds to the black box problem exposed by robo-debt. 2. Mandatory human intervention.
人工干预机制
A key proposal, human-in-the-loop safeguards.
人工干预机制
Human review should be triggered when penalties are severe, anomalies occur, individuals request review. This mirrors global best practice, including OECD, Organization for Economic Cooperation and Development, AI governance principles. 3. Equipment and evidence oversight. The article stresses strict review of device legality, data integrity, public disclosure. Automation must remain subordinate to law, not the other way around. Section 4. Key legal vocabulary and reflection. Let's recap core Chinese legal terms from today's episode. 1. Automated administrative penalties.
自动化行政处罚 2.
Due process principle.
正当程序原则 3.
Principle of proportionality.
比例原则 4.
Administrative discretion.
裁量权 5.
Human intervention mechanism.
人工干预机制
Reflection questions. Should efficiency ever override legality? Can automated systems ever exercise discretion? What did robo-debt teach us about trusting code with power? Conclusion, the future of administrative justice. China and Australia approach automation differently, but face the same dilemma. When government decisions become faster, law must become firmer. Automation can modernize governance, but only if due process survives, humans remain accountable, technology serves justice, not convenience.
法律之桥连接世界
The bridge of law connects our worlds. Stay connected.